for her part in organizing this meeting. So it's because of Liz that we've been introduced to David Brophy. And I will say also that it is because of the IP law section of the State Bar of Michigan that we know of David Brophy. So David has spoken for the IP law section at various events in the past. This is our first time with the privilege to hear from David. And I'm glad we can, because I think that we want to explore this relationship between IP law changes and consequences for trade. And so this is an important and timely issue. I'm glad David is here to address it. But I want to thank the IP law section, Liz Storm, and Matthew Kendall in particular, who is an officer of the IP law section, for introducing us to David. Jeffrey Paulson, who you may have met in the minutes leading up to this meeting, is a past president of the International Law section of the State Bar. Jeffrey helps us out on occasion still, and thank you, Jeffrey. With that, I would like to get to an introduction of David Brophy. David has an impressive resume, and that has been distributed to all, and I hope you've had a chance to review it. So let me briefly summarize it. David is licensed as a patent practitioner in at least 2 jurisdictions, those being Ireland and the EU. And if there are more, please let us know. But what I learned simply from reading his biography is that you've been published in publications of global reach, namely the European IP Law Review, the Japan IP Law Review. You've done an enormous amount of work in the area of patent prosecution on some very interesting technologies and topics. So what does that all mean? It means that you're very experienced, and you're experienced in the jurisdictions that are of interest today. So you bring the expertise that we want. The other thing I've had an opportunity to learn from you by talking with you personally, and we've talked on a couple occasions, and that's been interesting, and thanks for your time. But it seems to me that you're the kind of person who has exerted a lot of effort over the course of your life and continuously in learning. You're a person who has an appetite for learning, and you do it continuously. And what does that result in? Expertise, and demonstrably for you, because you've published blogs and submitted articles and done a lot of speaking, including here in Michigan. So we're really pleased to have someone with your background, experience, and expertise speaking on this topic of Brexit, especially since you're in a locality that is nearby, and you have a proximity to the issues that helps. So with that, that will be the conclusion of my introduction of you, David. But if I've left anything out, I would like you to address it in the first part of your talk. And as far as how the talk will proceed, I would suggest this, that you will be displaying slides. Is that true?
That's correct, yeah.
Typically, questions are easy to introduce when you come to the end of a slide. And what I like to ask the audience to do is to make a note of your question in the chat. So if your question comes up while David is speaking, make a note of it in the chat. And then I will look there. And David, you do not have to look there. You can present just freely. I will keep an eye on the chat. And if I see people typing up there, then I will interject at a slide transition and say, hey, so-and-so has a question. And if that so-and-so is not muted, I'll ask you to present your question. But I will lead that discussion, and I'll ask the people who have put a note in the conversation to articulate their question. And we'll do it like that. And then we'll have a chance for a freer set of questions perhaps at the end. David, what do you think about that as a template for the talk?
Yeah, that works for me, because as it happens, I'm working off one monitor here, so I'll have my presentation in front of me, and I won't be able to monitor the chat continually. So if you can throw the questions at me, I'm very happy to take them as I go along. I think it makes more sense.
Okay, so I will interject them when I see a natural pause, and I would once again ask the audience, just at least put your name in the chat if you have a question. It's a way of raising your hand, and it makes it very easy for us to call on you. So I'll be doing that as we go. With that, I would like to turn it over to David. So David, welcome, and thank you for being here.
Well, thank you very much, Eliot, and thanks to everybody who's made the time to come and listen to this. What I will try and do here is to share a presentation, and hopefully you will be able to see this.
While you're sharing that, I'll make one last comment, which is to ask the audience to mute themselves while we are not speaking. And that will give David a freer and better audio transmission. By the way, Thomas Geib, are you on? And are we streaming this to YouTube?
Yes, we are.
Okay. So if you want to review this after the fact, it will be on our YouTube channel. And that's a great way to check out anything you may have missed in the course of the conversation. David, please take it away.
Right. Okay. You can see my slides, can you?
I can. Great.
Yeah. Thanks. Okay. Well, thank you very much, Elliot, and thanks for inviting me. As you said, Liz Storm introduced us and I got to know Liz when I presented in Mackinac in 2016, and so I think this talk today and my talk in Mackinac kind of bookend the Brexit process because my talk then in July 2016 was 1 month to the day after the UK voted to leave the EU, which surprised everybody and led to me actually having to throw away my initially prepared talk and write a new one with 1 month to go. So when we're looking at Brexit, and I attended the talk last week, which the international law section ran, and you had a very good talk with speakers from the UK and the US and Germany. And they were talking about the issues of law that affect your clients arising out of Brexit. And they are, by and large, the same ones that I think we've all heard in the media. You know, will there be a trade deal? There's a meeting this evening between Boris Johnson and Ursula von der Leyen. We may find out something about that. I'm not going to speculate. And that obviously affects any of your clients that are doing business in Europe. There are issues about tariffs that will arise out of that. What will it cost to move goods back and forth across the border? There are issues of regulation. Who's going to set regulations? What happens if one side decides to go for, let's say, stronger environmental protection? Does the other side have to follow in lockstep, or can they move apart over time? What happens, I think, what the EU is most worried about, what happens if the UK decides to lower its level of regulation to make itself more competitive? Does that then breach any agreement they have? Issues of border delays are obviously going to affect everybody who's moving goods back and forth. I think at this point in time, there are going to be border delays, inevitably, whether there's a deal or not, just because the infrastructure isn't there. This photo was taken when the UK did a dry run of putting in place border controls, and it went disastrously wrong with these vehicles stacked up for miles on end. If there's no deal, those delays will be longer and will last for months, if not years. If there is a deal, hopefully that can be sorted out quickly. There are issues that people have talked about certifications. How do you license a vehicle so that it's compliant with the rules in the EU and in the UK? Who gets to decide what's called Scotch whisky? Is that something that is jointly decided? Is it part of the competence of the agreement? And so on. So all of these things are going to be issues of law that your clients may or may not have to deal with. And then fishing rights, which has come to the fore. I don't know whether it's come through in the media in the United States, but it's become one of the real sticking points, probably because it's an area of territoriality and sovereignty and so on, and promises were made to fishermen in each country that they wouldn't be affected, and clearly they will be. So these are all the issues that are getting the headlines, and they don't include IP whatsoever. And one thing they all have in common is they're all areas of public law. They're all areas where the companies and individuals who are operating in Europe are having to comply with the outcome of these discussions. They have to comply with the tax systems, the customs regulations, all of the other regulations that are going to be driven. And very few people, I think, are talking about issues of private law, about disputes between individuals. Now, this, I think, was touched on last week when one of your speakers was talking about the need to review contracts. Obviously, if you have contracts between parties and they are territorial and they reference the European Union, you need to review those. You need to review choice of forum. You need to review where the jurisdiction is for any new agreements. But other than that, we haven't heard a whole lot about private law. And IP is all about private law. IP is all about companies using their rights to prevent other companies from doing certain things. So it's IP is about who owns what and what can I stop you from doing. And to understand how that's going to change, I think, first of all, I want to, knowing that you're not all IP practitioners and some of you will be more interested than others, I wanted to just at a high level review what's going to change on the 1st of January in the field of IP. I didn't particularly like this stock photo when I got it, so I decided I had to just fix it to make it clear that Ireland is dividing in two at this point. You know, those of us living south of the border remain part of the EU, whereas north of the border, as I'm sure you all know, remains part of the UK, and that border is one of the real sticking points as to how seamless it can be. So looking at the first area, patents in Europe won't be affected very much, if at all. Already, at the moment, patents are separate national rights in Europe. That means that even though there is a European Patent Office that grants European patents, it's not an EU body and has no real connection with the EU. When you apply for a European patent, what you're actually granted at the date that it's granted is a bundle of national patents. You get a UK, German, French, Swiss, Spanish patent, all in parallel on the date of grant. And that will continue after Brexit. So the UK remains part of the European patent system. The European Patent Office will work as it has done prior to Brexit, and there's no change in your patent rights. The only thing that will change is there has been a proposal for, at this stage, years, if not decades, to have a unified patent covering all of the EU or most of the EU. And I spoke about this at length in 2016, saying that I didn't think it was going to happen anytime soon. And that's proved correct. The UK leaving this system has made it more difficult to put into practice. So that core proposal and that unified patent proposal, it didn't exist before the 1st of January, and it won't exist after the 1st of January for some time to come. So really, in patents, everything continues as it did before. In the area of copyright, again, copyrights in Europe are really separate national rights. Every country has its own copyright laws. When you've created a work that's entitled to copyright, you get it automatically in all of the countries, and each of those is individually enforceable as the right. Now, copyright isn't harmonized fully across Europe. So we have the same term of copyright, life plus 70 years. We have, in some fields, we have the same standards of protection in every country, the same criteria for what can be protected in some sectors, but not in every sector. And in the last 10 years in particular, the European Court of Justice has been very, very active in trying to fill in the gaps that the legislators have left. So the Court of Justice has effectively told countries that even though the Irish Copyright Act or the UK Copyright Act may define what can be protected in a certain way, that doesn't really matter. What really matters is our definition of it. So the European Court of Justice has driven everyone to the same level of copyright protection. And I would say it's probably a level that those of us from common law countries, and very similar to the US copyright system, those of us from those countries would be uncomfortable with the level of copyright that is coming out of Europe. But that's the way it is in Ireland. We have to live with that because we're subject to the jurisprudence of that court. The UK, after the 1st of January, won't be subject to that. And it's going to be very interesting for us to watch whether they continue on that same path or whether they take the opportunity to say, well, you know, that's too much for us. We want to revert back to what we had before, to a more traditional view as we see it of copyright. And if they do, then we will have diverging systems, and that will affect companies, not just in the arts and in the media industries, but companies who make physical products and who ship goods around Europe, surprisingly, and I will come to that. In the area of trademarks, the next big one, there already is harmonization, full harmonization. You have an EU trademark registration. It covers, at the moment, all 27 EU member states plus the UK. That registration that you have today on the 1st of January won't cover the UK. The UK drops out of the system, and in order to fill in that gap, the UK is automatically creating a new registration for every EU registration. So you end up with 2 registrations, one in Europe, one in the UK, and that will happen automatically at no cost to anyone. So you get full protection in the UK seamlessly. The only complication really is, well, there are 2. One is if you have applied to register a trademark and it hasn't yet gone through. In that case, you have to reapply in the UK if you want to get that trademark protection. So that's something that has to be done within 9 months. The other area which is longer term is just like in the United States, if you have a trademark registration, you have to use your trademark in commerce to keep it valid. And the same in Europe. You must use your trademark in the EU for your EU trademark to remain valid. Now, a lot of companies have only ever used their trademark in the United Kingdom, and that has been good enough up till now to keep their trademarks valid. But after 2021, after that point, using a trademark in the UK won't be used in the EU. And so there's a period of 5 years where people will have to put their trademarks into use in Europe to keep their European trademark registrations valid. And likewise, if they've only ever used it in France and Germany, they will have to start using their trademark in the UK to keep this cloned registration valid come 2021. So 5 years to get all of that into place, but it is something for people to be aware of. In the area of designs, which you would call design patents, we are very similar to trademarks. We have a single registration covering 27 countries plus the UK. And like in trademarks, on the 1st of January, the UK drops out of that system and creates a cloned registration that will just apply to the UK. So that's going to be very similar to trademarks. And again, it should be seamless for most companies. And then the last area I just want to talk about, and it's probably the least familiar to US practitioners and maybe the most complicated as well for us, is unregistered design. So if you have a new product and you disclose it in Europe, you are automatically given 3 years of protection against anyone copying the design of your product. That's something that we've had for a long time now in Europe. On the 1st of January, the UK drops out of that system as well. So let's say you had disclosed a product 2 years ago. You've got 1 year left of protection for unregistered protection. The UK will give you that year. They will give you a year's worth of protection in the UK from the 1st of January so that the term runs out. But after the 1st of January, for any new product, you can either get UK protection or EU protection. You may not be able to get both. And that's something I want to talk about at the very end. So this can be very useful for short-lived products, for the fashion industry, even for the auto industry, where models come and go quickly, and maybe they're not all protected by the registered rights. People rely on these unregistered rights, and there's a bit of planning to be done in order to make sure that you don't lose out. So when we look at all of those in sum, everything that currently exists will either continue on unchanged or will be cloned where it's necessary to clone it so that the right owners don't lose out come the 1st of January. And in future, there will be parallel rights available for everything that you can get in the EU, you'll be able to get in the UK. And that raises the question, if nothing much is changing in the world of IP, what am I going to talk about for the rest of this talk? And what's the problem? Well, there really is a couple of problems. One of them is the problem that the EU has struggled with, since 1957 when it all kicked off. Free movement of goods is inherently in conflict with intellectual property. And the Court of Justice has looked at this on many occasions over the years, where people have tried to rely on their IP rights to stop goods from moving between countries. And the Court of Justice has had to decide, are you allowed to stop goods moving around within Europe using your IP, or is free movement more important? And in general, they've felt that free movement is more important.
David, may I interject one question right there?
Yeah.
Thank you for summarizing the parts of IP law that matter here and how those will be separated. And so a question is this. You mentioned that the Court of Justice of the European Union adjudicates copyright questions. And do they also adjudicate patent questions, trademark questions? Are they the last stop for any dispute concerning all of the IP rights that you mentioned?
They're the last stop for copyright because that is usually the subject of EU legislation, for trademarks and for designs, because they're completely harmonized also. So they are the court of final arbitration. You know, if there's questions that a national court has that relate to European protection, they refer it up to the Court of Justice that gives the final say. For patents, that's not the case, because patents are not within the competence, by and large, they're not within the competence of the EU. So the Court of Justice, except for a few very limited areas, supplementary protection certificates for pharmaceuticals, which are a very niche area of patents, in general, you know, each country has its own Supreme Court or equivalent, and that will be the final level of arbitration. For issues of patentability, there's also the European Patent Office has an enlarged board which sort of decides on what's protectable, what's not, and that would every court in every country would give deference to those rulings, but not the Court of Justice for patents.
And did I hear correctly that there are a couple rights that could expire if you don't do something after Brexit? Those being to use a mark in commerce in an appropriate jurisdiction. Could you comment on those again? And that applies to designs as well. Did I understand that or not?
No, just that only applies to trademarks. So in trademarks, you must use it in commerce. The way it has worked up till now is the Court of Justice has said, if you use it in one country of the European Union, that's in general, that's good enough to support your entire EU trademark. But if that country where you used it, that one country, was the United Kingdom, the question arises, does that now support your EU trademark? And what they've said is that any use up till now has been good enough, but within 5 years of January the 1st, you must start to use it in other EU countries, or else you could lose it's open to attack at that point.
Any time in those 5 years?
Any time in those 5 years, yeah.
Okay.
So there's basically a moratorium. This is something that a third party would attack your trademark right and say it hasn't been used. There's a moratorium of 5 years during which that can't happen if you had used it in the UK up till now.
Understood. Thank you.
Okay. Thanks, Elliot. So when we're looking at IP for patents and trademarks and designs, in general, the legislation says that one of the things that is an infringement is an act of importation. So bringing a patented product into Ireland, into the UK, into Luxembourg is an infringement of your Irish, UK, Luxembourg patent, and the same for trademark and the same for design. And companies are used to relying on that to stop third-party goods from coming into these countries. It's one of the best ways of stopping an infringement. But the question then arises, can a company use its own patent, its own trademark to stop other people from bringing in the company's goods into the jurisdiction? So can I use my IP rights to stop you from bringing my products from another country? And that will happen, or that may happen, if I'm selling my goods in two countries, country A and country B, and in country A, for whatever reason, I'm selling it at a cheaper price, and in country B, I'm able to sell it at a premium price. There's then an opportunity, obviously, for you to buy in country A, import it into country B, and undercut me. And that's happened many, many times throughout the history of the EU. And the reasons for the price disparities can be, multiple. But on each occasion, the Court of Justice has been asked, what are the circumstances in which I can stop my own products from moving around the EU? Create my own barriers within this seamless market. I'm erecting barriers that are based on my IP, whether that's allowed. So in order to look at that, I wanted, first of all, and this is risky, I know, when I'm talking to a group of US attorneys, I wanted to look at what happens in the United States. And I'm prepared fully to be wrong on what I say here, but this is where you can interject, and I'm glad you're all on mute. In this case, which was Impression against Lexmark, Lexmark sell printer cartridges, and they have a system for having the cartridges refilled. So they've a program where you can have the cartridges sent back to Lexmark. They refill them and then they put them back out on the market as part of their program. Impression went out into the market and bought Lexmark cartridges, both in the United States and abroad. It bought genuine Lexmark print cartridges, and then it refilled them with ink, and then it put them on the market at a cheaper price than Lexmark were doing. So because the cartridges contained patented technology, Lexmark said, this is an infringement of our patent. And the Supreme Court said, first of all, they looked at the ones that were acquired in the US and resold in the US. And then they looked at the ones that were acquired abroad and resold in the US. And they said, in the US, when you sell a product, basically you exhaust your patent rights in those products. So you can't enforce your patent rights after you've made your first sale. The person who buys them gets an unfettered right to do what they want with that product, unfettered by your patent. And then they looked at the ones that had been bought abroad, and they said they could see no difference. They said they saw no reason why the same doctrine didn't apply. So if Impression was able to buy Lexmark print cartridges abroad, then the patent rights were also exhausted for those print cartridges, and Impression were allowed to refill them and resell them in the US market without this being an infringement. So their patent rights were exhausted internationally under the US approach. When almost exactly the same set of circumstances happened in Europe, we got a very different answer. So Silhouette made spectacle frames, and Harlauer were a competitor of theirs. Harlauer were refused the right to sell Silhouette's spectacles in Austria, where they were both based. And so Harlauer went outside the EU and they bought genuine Silhouette spectacle frames outside the EU and did the same as Impression had done. They brought them back into the EU and they sold them in Austria, undercutting Silhouette within their home market. And in this case, it was a trademark infringement that Silhouette sued for. And what the Court of Justice said was that when Silhouette sold its product outside the EU, it didn't exhaust its trademark rights. So it was still entitled to enforce its trademark against the product coming back into the EU because it had never consented to put it on the market in the EU. So we have what's called regional exhaustion here, or it's also known as Fortress Europe. So basically there's free movement. Once you put your goods on the market within Europe, I can do anything with your goods. I can buy them, I can sell them, subject to, some areas of pharmaceuticals. There may be different regulatory stuff I have to work around. But in general, I can buy your product in country A within the EU, if you sold it there, and sell it within country B, and you can't do anything about it. But I can't buy it in the United States or Brazil or Russia. I can't buy your product there and bring it into the EU because that will infringe your patent or your trademark or your design. So very, very different approaches on this question. And of course, this is relevant for Brexit because the UK, which is now in the EU, is suddenly going to be outside the EU come January the 1st. The UK has decided that it's going to subscribe to international exhaustion, just like the US. This means that people who own IP rights in the United Kingdom will not be able to stop their own goods from coming in from any of the EU countries. Okay, so that's going to be very different to how the EU is going to approach it come January 1st. Come January 1st, the EU is saying, we're changing nothing. We still have Fortress Europe, and now UK, you're outside Fortress Europe. That means that if you own rights in any of the EU countries, you can prevent your goods from being bought in the UK and brought into the rest of the EU. And that obviously raises opportunities for people to arbitrage on price or to create price differences. It creates opportunities for importers in one direction. It creates opportunities for rights holders in the other direction. So looking at how this actually works, I mean, this is a big issue in practice. It's a big issue for consumers and for companies. There's maybe the largest Irish bookseller, domestic Irish bookseller, is called Eason, and they've got shops and they've got an online presence. And the largest bookseller in the UK is Amazon's wing, amazon.co.uk. So I thought I would go on there and have a look, because Elliot's budget for this didn't extend to anything more expensive than buying a paperback book. So I thought I would do an experiment and go on there and look for a Michigan author who was on sale. I started off looking for Tim Allen, who wrote a fantastic autobiography, which you should all read sometime. But then I moved on to Elmore Leonard. And you can see here there's a big price differential. Elmore Leonard is his complete Western stories. They sell in the Irish bookstore for €23.80 and for the equivalent of about €14.30 in Amazon UK. And at the moment, I can choose where I want to buy this book. I can go onto either store and I can buy it. And there's free shipping in both cases, so it makes sense for me to shop in Amazon UK. Come the 1st of January, Amazon, when I buy from Amazon, I may have to pay more taxes. We've heard about taxes and tariffs. There may be import problems, there may be delays, and there may be all of these public law problems with me buying from Amazon, but I'll still be able to buy from there, I imagine. What I can't control is that the publisher, come January the 1st, the publisher may decide that Amazon UK is infringing the copyright that it's holding on behalf of Elmore Leonard. It may decide that's an infringement to sell into Ireland or into any other EU country. And it may decide that Amazon is no longer entitled to sell into these countries. And so the publisher may decide it wants to divide up markets between the UK and the rest of the EU. So that's a practical example. And I think we will see probably not for sale in the EU, and people who go onto UK shops and websites won't be able to buy certain products. A much more likely example where we're going to see immediate restrictions will be in the auto industry. And I know this is obviously a major interest for Detroit and for Michigan attorneys in general. This is a website of a company that is based in Northern Ireland, and they have this webpage directed to customers from the rest of Ireland. And they're saying, you can make savings. It would cost you €22,000 to buy this car in Ireland. We can sell it to you for just over €17,000. So, this is something that Skoda, who are the car manufacturer, are not allowed to prevent under EU law at the moment. They cannot stop this company from selling to an Irish customer. But come the 1st of January, they will be able to stop, and they will stop it. They will prevent these companies from selling into Ireland. They will divide up the market because it makes sense for them to do so. I actually did this about 5 years ago. I went to Northern Ireland and I bought a car, and I saved myself a couple of grand on the car. And I took this picture as I drove home, and it's not the best photograph in the world. But this is a picture that I took as I crossed the border, and some of you will actually have seen this in 2016, crossing the border from the UK into Ireland as I drove home. And the only sign you have that you cross the border is that the colour of the lines on the side of the road changes, because we've got different rules about what colour the lines should be. And we do our speed limits in kilometres per hour rather than miles per hour. Other than that, it is a seamless transition. And this, I only bring it up because when you hear about the border in Northern Ireland and how difficult it's going to be to get Brexit done and to have customs checks, this is the way it is at the moment. There's no stopping anyone going across the border. There's no stopping goods or people. And this is why Northern Ireland and Ireland are a particular difficulty for Brexit. For all these products, whether it's books or cars, exchange rates are a big issue, and you can sterling has decreased relative to the euro.
Hey, David, it's Elliot Church here. I'm going to break in for a second. We're experiencing a little bit of an audio disruption from you, so I'm going to ask you to just back up to the beginning of the slide and re-begin your talk from the beginning of this slide. Exchange rate as an incentive.
Okay. Can you hear me okay now, Elliot?
So let's give it a go.
Good. Okay, I think microphones needed. Are artificially cheap because of the National Health Service, and they're buying medicines there, and they're bringing them to countries like Germany.
Is this going to be a problem with the new mic?
Yeah. I think, why don't you sign out and then sign back into the meeting, and let's see if you get a better connection. We'll wait for you. Take your time.
Okay.
Right. So while we're waiting for David to sign back in, and I apologize, but this is the nature of this mode of communication. There are sometimes problems, and we can't avoid them. So we'll do our best to get David back on, and hopefully that international connection will be stronger this time around. But in the meantime, while we're waiting for David to sign back on, I want to talk a little bit about events that are coming up, which the International Law section will be hosting as well. And we have a talk tentatively scheduled for January 13th. And that, Liz, if I recall correctly, is going to be on music, trade in music, really. And it's somewhat related to this, which is how do we transact business in music, which is subject to copyrights across borders? And there's lots of jurisdictions where rights apply. And so we've just learned a bit about that from David Brophy. But there are lots of licensing agencies. So that's a complicated aspect of international commerce that we're hoping to learn more about. Have I characterized that correctly, Liz?
I think so. Correct. You mentioned we have a speaker, Peter Strand, from the chair of the ABA Sports and Entertainment Committee. He will be talking about some of the updates and changes to the Copyright Act, Article 17.
Great. So that will be on January 13. On January 27, we are having a talk on international dispute resolution, and that will be offered by Stuart Patterson, who is an attorney based in, I think he's based in Dubai. So he's had a lot of experience in international arbitration. So that should be an interesting talk from an area of the world where I don't think we've had a speaker recently. And then on February 17, we'll have John Yormick, who is an Ohio attorney who's done a lot of work in the area of export and customs. So he'll be speaking about some of the trending issues in those areas, especially what with the advent of some new tariffs and some new enforcement mechanisms. So we are taking this opportunity of COVID-19 to bring in speakers from around the world where we don't normally have the opportunity to do that. So this has been a really fun opportunity to reach out to our connections around the world and get people involved who we would not ordinarily be able to hear from. So I want to check now to see if we have David Brophy back on. And it looks like we do. David, do you want to give it another go?
Yeah, I'm not sure. I've just moved slightly as well, so hopefully I've got maybe a slightly better connection. Can you hear me okay? Yeah, good. Okay.
I do.
And apologies to everyone for the disruption. I hope you have managed to follow what's roughly what I've been saying. So I was talking about the drivers for these parallel imports, and I was talking about the sector where it's happening the most, which is the pharmaceutical sector, and it's a big business, $5.5 billion worth of trade annually, a lot of which is stuff that's bought in the UK and brought into the rest of the EU, which will be cut off. This will be like turning off a tap on January the 1st. The pharmaceutical companies can't afford to mess around with this stuff. And if they see people trying to acquire product in the UK, it will be an infringement of their patents, an infringement of their trademarks, and they will stop it on January the 1st. To give you an idea of what we're looking at here, for each country that's listed, they've got the direct savings, which is how much consumers saved by buying these cheaper parallel imports, and then the indirect savings, which is in the case of Germany are enormous, which is the amount that the original manufacturer had to drop its own prices to compensate for the fact that there were these cheap products coming in. So this is where these figures are coming from. So when I hear about tariffs, and all of the talk is about tariffs, the tariffs certainly do provide a disincentive for people to be trading across borders in the context of Brexit. But IP is going to create an absolute legal barrier for some of these products, and it shouldn't be underestimated how powerful it will be for some industries, in particular, I think, the auto industry and the pharmaceutical industry. So take away from that, IP owners will have opportunities to block their goods going into the EU from the UK. They won't be able to block them in the reverse direction. So that opens up opportunities, or at least it keeps open opportunities for people who want to trade in these goods and who spot these opportunities. And you get the possibility of dividing up Europe. And that possibility will increase where it doesn't exist at the moment. For IP owners, in order to take advantage of this, or at least not be disadvantaged, it's really important to take those steps that we talked about earlier to make sure that your IP is fully protected in all of the jurisdictions, in both jurisdictions. Moving on to copyright, I said that the EU is driving copyright in a direction away from the traditional view in the United States, the UK and Ireland. And I wanted to illustrate that with a look at a US case, Star Athletica. This was a company that makes cheerleading uniforms, and they claimed copyright and they registered the copyright in a number of their uniforms, in fact, in hundreds of their uniforms. So these are arrangements of stars and stripes and different patterns and so on. And the question was, to what extent does copyright protect this kind of garment or this kind of pattern? And what the Supreme Court said is, when you've got a useful article, like a cheerleading uniform or a teapot or whatever else, if the sole intrinsic function is utility, the fact that it's unique and attractively shaped does not qualify it as a work of art. So they wanted, this was in the context of separating out the copyright work, which was if you like, the painting that was applied to these cheerleading uniforms, from the article itself. And so they make, in the US, the Supreme Court makes a clear distinction between the product and this separate design. And they said, even if Star Athletica ultimately succeed in their copyright claim for the surface decoration, they've no right to prohibit any person from manufacturing a cheerleading uniform of identical shape, cut, and dimensions. And this is something that traditionally, those of us who work in copyright in the UK and in Ireland would be very comfortable with this view of the law, that you don't use copyright to protect something like a cheerleading uniform, but maybe you can protect the surface decoration. Now, contrast that with the EU. They had a case with Cofamel and G-Star Raw over pairs of jeans and the cut and design of a pair of jeans. And they said, we don't worry about what the nature of the product is. We don't care about that. All that matters, and it's necessary and sufficient, that the subject matter of whatever is claimed reflects the personality of its author as an expression of free creative choices. So they say that if the person who designs this pair of jeans puts their personality into it, has the freedom to make various choices and exercises those choices, that may be enough for it to be a copyright work. And that would, in contrast to what the Supreme Court said about cheerleading uniforms, that would allow the owner of the copyright to stop other people from selling jeans with the same cut and the same shape. So that's where there's been this big divergence. Even more so, this is a product that I don't believe any US attorney would say could be protected by copyright in the United States. The shape of this bicycle, it's a folding bicycle. But the Court of Justice within the last year said that when they looked at this bicycle, they said the shape of this product, the author expressed his creative ability in an original manner by making free and creative choices, and designed the product in such a way that it reflects his personality. So this product is protected by copyright, which has an enormous, in my view, an enormous impact on this market in Europe, because copyright is going to last until this author, whoever he or she was, is dead. And for 70 years afterwards, nobody can make a bike that looks like this in the EU. And that's really alien to our way of thinking, where something like the design of a bike should be protected maybe by a patent, maybe by a design patent in the States or a design registration for 17 years, 20 years, 25 years, and then it expires, and then everybody is entitled to compete in this product. But for this bicycle, because of this decision, you won't be able to make one of these bikes for 100 years if you're not the author. And that seems to me it seems to me to be a stretch, an overreach, but that's the way that the copyright has gone. So At the moment, the UK, when we look at this, and if you have companies that are selling products like this that have quite a bit of design in them, but they're still utilitarian products. At the moment, the UK is bound to respect the fact that these products could have copyright. But come January the 1st, the UK won't be bound by that precedent. And I think my feeling is the UK will move away from this and will feel more comfortable in reverting back its level of protection towards what you have in the United States. And that means that if you design and make these products and sell them in Europe, you're going to face copies in the UK decades before you face copies in the rest of Europe. So if the UK doesn't continue on this line, which I think the courts are very uncomfortable with, I think we're going to see a big divergence in copyright, which isn't just impacting on the creative arts, it's impacting on industry and on products like bicycles and jeans. The last area I want to talk about is unregistered designs. This is it's a picture from a case where Ferrari took a case against a company called Mansory. And Mansory make body kits. So they make spoilers and wings and body panels that if you can only afford a €400,000 Ferrari, you buy these panels and you can make it look like a €1.2 million Ferrari. So if that's what floats your boat, Mansory are the people to go to. And Ferrari objected to Mansory selling these body panels, including the one that I've outlined in red, saying that even though they didn't have a design registration on that part of the car, they had unregistered design rights on it. And the reason I mention this is, A, to draw your attention to this as a very useful way for Ferrari to try to take someone off the market. Now, the case is still not decided, but in theory they can. But to say that the reason Ferrari were able to do this in the first place is because they launched that Ferrari car at the Mugello circuit in Italy. And because they launched it in the EU, that was the first disclosure, and that meant that they get EU design rights, EU unregistered design rights. Come the 1st of January, if you launch your product in the UK, you won't get EU unregistered design rights. And if you launch it in Italy, you won't get UK unregistered design rights. You're going to have to choose where you disclose your product first. And the choice that you make will determine which of those two rights you can get. So if you make your disclosure in the EU, you get the EU right, but not the UK one, and vice versa. And if you make your first disclosure anywhere else, if you do it at the Detroit Motor Show, then you don't get any EU or any UK unregistered rights. So there is strategy here where companies particularly are making products just for the European market, deciding where are they going to launch. There's a question whether it's undecided. Can you do it on the internet and say, well, that's a first disclosure in both jurisdictions? Nobody knows. The takeaway, I think, is if you can register your design, you should register it, because then you're not bound by these choices. But it is something, just a piece of strategy to build into how you bring products to the market and how you disclose it and where you put them on the market. And with that, I think I have reached the end of the remarks I was going to give, but I'm very happy to take any questions or to let you get back to your working day and let me go back to my dinner.
Well, we're not going to let you go back to your dinner, David. Right. So we're going to ask some questions to prevent that. But let's start working backward a bit. Unregistered versus registered. What's the bar to registration? My guess is that it takes a little longer. You might not get it in time to protect something that is, in fact, more appropriately protected by unregistered rights. What's the bar? What are the hurdles?
Cost is the only hurdle. I mean, delay isn't, because the EU registration system is very quick, a matter of days or weeks, and you can get a registration. So it doesn't tend to be delay. It tends to be cost. And as you saw with the Ferrari design, you can see that they basically almost cut out a part of the car's design and said, that's the right that we're claiming. Okay. Now you could do that in a registration. You could apply for the whole shape of the car, plus that part of the bonnet and the front bumper, plus the side wing, plus the wheel, plus that. But you would be filing a whole load of designs for all of these individual bits and pieces. And what you'd be trying to do is predict where the infringement was going to come. So companies will do an element of that. They will file for bits and pieces of their product in registrations, but they can't predict everything. And so the unregistered is there really as a catch-all to try to back up, any gaps you have in your registrations.
I understand. Okay, so it's part of a composite strategy for defending the design. You have the things that you can predict might be infringed, and then you might not be able to predict, but you would
Exactly.
bring that cause of action under the unregistered. Now, tell me about the bike. Let's go back to the bike example. So if I have a copyright on a bike like that, I'm thinking this is somehow like design rights. And when I think about registering design rights, I think that a lot of things, when I'm thinking about a U.S. design patent application, for instance, there's a lot of things that are kind of blanked out. They're like, no, this is utilitarian. This is not part of the design. And we sort of identify in a nuanced way what the design consists of. I can replicate anything else, but this is the design. And is that true for the European copyright rulings like they are? Is it just the whole bike? You can't make anything like it in any regard.
You can claim copyright in whatever you want because it's an unregistered form of protection. When you are suing for infringement, you're suing on the basis that the infringer has copied a substantial part of your work. So the task that you have is to convince the court that the part that they copied is substantial in the sense, not in the sense of quantity, but in the sense of quality. So you're trying to say that when you read the language that I quoted, which seems very, I'm sure, very nebulous to you, where they talk about the author's expression of his personality in the product, the creative choices. If you copy the author's expression of personality, you don't have to copy the whole product. So just copying that. So if you take a famous painting, it might just be, a small part of the painting is enough to copy that. You're taking part of the author's personality or the expression of the personality. So it's really whether the bits that are seen as most creative appear in the copied work. That will be an infringement.
So it sounds like that ruling is setting up the EU for a lot of litigation on exactly this issue.
I think it is. I mean, yeah.
There's a question from Nicholas Goubert de Blouet. Nicholas, do you want to present your question directly to David, or should I read it? Nicholas, if you're there, feel free to pipe up and ask your question. Or if I don't hear from you, I'll ask it myself. Okay, I will give you Nicholas's question. Nicholas, is that you? I don't hear Nicholas, so let me present the question. So Nicholas asks, will the UK continue to be a member of the European Patent Office, since the European Patent Office grants a bundle of national registrations? So
the answer is yes.
Okay.
Yeah, so the answer is yes. The membership of the European Patent Convention, the European Patent Organization, and being part of the European Patent Office is an intergovernmental agreement that's not connected to EU membership. It does so happen that all of the EU member states are also part of the EPO, but there's a bunch of other countries that are not part of the EU that are still in the EPO. So the European Patent Office isn't connected to EU membership, and Brexit doesn't affect the EU's participation in that.
Thank you, David. Are there other questions for David before we let him get to dinner? We have about 2 minutes left, so there's probably time for one more question if anyone has one. Final questions? Final questions for David? Okay, I guess I'll just ask you a general question, and I'm gonna hark back to the talk that was given last week, and I kind of want your opinion on the issues, the difference of opinion there. So the difference of opinion seemed to be, hey, this is bad for the UK, things are going to go south. And that was the opinion, I would say, of the folks who were representing the European Union. And the opinion of the folks who were within the UK seemed to be, no, things will continue as usual. And I think there was evidence on both sides. What's your personal opinion?
Well, I mean, I'm coming from a country. I mean, our firm has offices in Dublin and in Belfast. So we work on both sides of the border. So we're going to be affected either way. And I'm coming from the country in the EU that is going to be most affected by Brexit. So, Brexit, in my view, and in the view of, I think, every commentator in this country, Brexit will be bad for the UK. It will be bad for the EU. It will be worse for the UK by a considerable amount. It will be worse for the UK than for the EU. But within the EU, if we're comparing pain, I think Ireland is going to come out pretty close to the top of the scale because of our interdependence and the amount of trade between us. Since the start, it has been clear that the EU has been saying there's nothing to see here. It's not going to be a problem. We'll be okay. But I don't think the evidence backs that up. I think there is going to be pain on both sides.
David, thank you for your opinion on that. Thank you for speaking. I thought you brought a very interesting perspective on this and pointed out some really interesting trade issues. So thanks for commenting on that. I haven't heard a talk like that. So feel free to come back if you want to give a reprise. You mentioned that you might be writing something up, and if you do, feel free to send it our way, and we'd be happy to distribute that. So thanks to all who participated today, and I will sign off now. And David, I'll just give you the last word.
Okay, well, thank you very much, Elliot. It was a pleasure to be able to talk to you, even at a distance, and to see some familiar names and faces. And hopefully I get to do this in person in Michigan very shortly.
Wonderful. Well, best wishes to you, to Ireland in the upcoming transition, and hope all goes well. Take care. Best wishes, and we'll see everyone in the new year.